recap, review and submit, answer any sort of surveys that are coming your way, whether you're fully insured or self-funded. And then in the future, you will really want to revise and review your vendor contracts to understand how they will assist you with this in the future. Because I think depending on which medical TPA or pharmacy benefit manager you use, there can be very different service expectations and provisions that are provided to you, not only with this requirement, but other requirements. And you want to select a TPA that is going to help you and do some of this heavy lifting rather than using one that maybe leaves it all to you and then you've got to scramble and figure it out. So ultimately, that's where we are at right now. And again, if you're a little bit confused about this or concerned about this, please reach out to Benacurve and we can take a look and see what the status is regarding RxDC. Again, if you're self-insured or even if you're fully insured. Fully insured, I would be less worried about. Self-insured, you want to know for sure. And by the way, if you all have any questions, please type them into the chat and I will have time to answer any questions. Okay, so turning our attention to just some reminders and updates. A couple of things here to bring your attention to. First, we have a new CHIP notice. So the CHIP notice is required to be given to employees upon enrollment. And so this notice, you probably have seen it before, it usually has children's health plan insurance information on it. And then it has each one of the states and their various lines and contact data for that particular state's CHIP program. And so this notice was recently updated in January. You will receive copies of these slides and we've linked it here just so you can take a look at that updated notice and make sure that it's given out in your open enrollment and new hire materials. Then we're going to look at the 2025 penalties A and B under the employer mandate. Those were announced and how that applies to you. I also want to talk about these alerts that came from both the IRS and HHS regarding reimbursements under FSAs, and also just a reminder in the wake of the United Health Group cyber attack on covered entities and how HIPAA applies to covered entities. So first of all, turning to 2025 ACA penalties. So we are just now in the 2024 tax year. So these penalties would not apply until 2025, but they are so similar. We have penalties for 2024, for 2023. They just issue different amounts each year, and sometimes they go up a little bit or down a little bit, but they're essentially the same. So whether or not we're talking about 2025 or 2024 or 2023, these around the same amounts for penalty A and penalty B are going to apply for employers that are subject to the employer mandate in the first place. And if you are subject to the employer mandate, there could be penalty A or penalty B that might be assessed for failure to offer a certain level of coverage. So let me just review this quickly. So penalty A for 2025 is going to decrease actually a little bit to $2,900 for the year, and that would be $241 per month because it's usually assessed on a monthly basis. Penalty B, in other words, would decrease to $4,350 for the year, which equates to $362.50 per month. Again, this would apply for the 2025 tax year, which won't even come around until next year. And then we submit 1095-C forms for those for that tax year in early 2026. So again, just to know that these penalties have been assessed for many years, and that they apply similarly across any tax year. So how you avoid penalties. First of all, if you're an applicable large employer, meaning you have more than 50 full-time employees plus full-time equivalents, which are essentially part-time hours that are factored to make a full-time equivalent body or full-time equivalent employee. And so on average, if you have over the full course of the calendar year, on average, 50 or more full-time employees plus those equivalents, then you are subject to the employer mandate. You're what we call an applicable large employer, and you have to do the 1095-C forms. Some of you know for sure that this is you, that this applies to you. Some of you may be hovering around that 50 mark and you're a little worried about whether or not this applies to you. So it's something you got to get clear on. Again, if you're not sure if you're an ALE, please reach out to us because we need to take a look at that because it could mean penalties for failure to file. So if you are, in fact, an applicable large employer, then that means that you have to offer coverage, basically major medical coverage, to at least 95% of your full-time employees and their dependents, their children, not necessarily their spouse, but their dependent children. This is an ACA rule. Also, that coverage needs to be meeting affordability standards, and it needs to meet minimum value. Most major medical plans out there meet minimum value, so that bar is cleared quite easily. The one that is a little more difficult and you have to really scrutinize is whether or not that coverage for the lowest cost plan is affordable to the employees. And so there's three methods that you use to determine whether or not the coverage is in fact affordable. You have to use federal poverty level, or FPL. You have to use their rate of pay, or you have to use the employee's W-2. So two of those are actually based on what the employee is making. The other one is only factoring what is federal poverty level. So it doesn't necessarily even relate to what any of your employees are making. So you have to use one of those three methods to determine whether or not your major medical insurance is in fact affordable to that employee. You would use the lowest cost plan and the employee only rate, regardless of if they took a higher cost plan or they enrolled their family members. You really just have to look at that employee only coverage for the lowest cost plan. So the affordability discussion is for another day because it is a little bit technical. But overall, to avoid penalties, you have to offer coverage to at least 95% of your full-timers eligibles. And that coverage really needs to be affordable. Those are the two things you're going to have to watch most carefully. That also means that you need to submit your 1095C forms and 1094C forms, which are like healthcare W-2s, to the IRS no later than generally the end of March, and you have to file them electronically. So most of you on this call probably are applicable large employers. You've done your ACA reporting. You know that your coverage is affordable. You've looked at this before. But if this is something that's a little newer to you, this will be something that we want to help you understand and educate you on. So again, please reach out to BeneCurve if you have some concerns about your particular situation. But ultimately, I wanted to highlight these new penalties and how they work because they can be they can catch some employers off guard if they're not really sure if they're large enough to be subject to that employer mandate. So we've been dealing with the employer mandate now for 10 years. So the IRS is kind of done with any good faith effort or any sort of leniency. They really feel like employers should know this by now, and it is not up to your broker or your insurance company to identify this for you. This is an employer plan sponsor responsibility, 100%. We can help you with that, but this is your responsibility, and you must take steps to ensure that you are compliant with this. Otherwise, you're going to face penalties, and that's not what we want to happen. So moving over to another hot topic that came up that I thought was interesting. The IRS issued an alert a couple of weeks ago now, on March 6th, that you can see linked at the bottom there, that I would take a moment to read. It's a couple of paragraphs. It's fairly short and easy to understand. But ultimately, what this alert was warning against is FSAs, specifically FSAs that reimburse medical expenses, or HRAs or even HSAs that allow employees to pay for or be reimbursed for what we would call Code 213D medical expenses. It's basically saying that you got to keep in mind, if you offer specifically an FSA where this really comes in, those FSAs and the vendors cannot reimburse general personal health and wellness expenses. So the example that it gives here is a diabetic who sees a commercial about low glycemic food or low carb food, and then they are told if they can call into this company's hotline, they can get a doctor's note to receive those foods through their FSA. In other words, that food can be bought through their FSA on a tax-free basis. And so the IRS says, no, you cannot. This is not permissible under our rules because you have to have something that's tied to a diagnosis, and it can't be just general um, uh, dietary means. It can't be this, we get low carb food reimbursed tax free. It has to be something that's actually curing or mitigating a disease apart from just normal dietary means. So I don't want to make this too complicated, but overall, food and diet drinks and things like that typically are not reimbursable under FSAs. And so when you sponsor an FSA, a flexible spending account, it is a very good idea to use a competent administrator to administer your claims, to review claims, because they are positioned uniquely to be able to examine certain claims and if they're reimbursable or not, and they can deny the claims rather than you having to try to deny them yourself. So having that independent third party is key in the administration of an FSA or an HRA because they're quite similar. So overall, really, if an FSA, if you as the employer sponsoring an FSA were to allow these types of ineligible medical expenses to be reimbursed, that puts the entire plan at jeopardy. And what that can mean is that all, not just for that individual, but all claims, all pre-tax reimbursements would become part of their gross income for all participants, thereby making it almost like null and void for the entire plan. So you really, really have to be careful with the reimbursements that are permitted for employees' medical expenses. So again, using a competent TPA or vendor to administer these claims is key. Otherwise, it puts your whole plan at risk and your employees at risk for making all of their reimbursements taxable across everyone who's participating for one failure. So I don't say that to alarm anyone, but again, these types of things where you see things advertised, they're not always squaring up with the IRS. It's just simply companies trying things that they think their lawyers have said, I think this would work under an FSA, and the IRS slaps it down and says, no, this is not something that's permissible under an FSA. Overall, it's really got to be related to the mitigation of a disease, a diagnosis, not necessarily just healthy foods. So I wanted to highlight that alert because I thought it was interesting, and it really does kind of bring to the forefront the need to scrutinize claims, and that's why you'd want to use a third party to scrutinize those claims on your behalf. If y'all have any questions, please just type them into the chat on any of these topics. Okay, the last thing I want to talk about before moving into the Johnson & Johnson lawsuit is a reminder that came about from OCR, which is the Office of Civil Rights. So this office is administered by Health and Human Services, HHS, and they are the governing body tasked with HIPAA compliance. And so you may have heard about in the news recently that United Health Group, there was a cyber attack that was involved with one of their subsidiary companies. I believe there was some sort of ransomware attack. And what I think that brought about is, again, this reminder that covered entities who are subject to HIPAA, considered covered entities, must safeguard their protected health information under HIPAA. It is a top priority for OCR. So under this letter, which again I would take a look at because it's all probably 2 pages as well. It's fairly short. This letter highlights that covered entities, again, are not only health insurance carriers, hospitals, doctors' offices, clearinghouses, but it also applies to group health plans. And so especially if you are a self-funded group health plan, you are subject to the full brunt of HIPAA, just like United Health Group is, because that plan maintains, stores, transmits, it has protected health information. 100% it does. And there's really no way to say, we're out of that. We don't see it. You can't be when you're self-insured. You are hands-on, in other words. There's no other way you can be when you're self-funded. So for self-funded plans, this brings a good reminder that First of all, you're subject to HIPAA privacy and security in the first place. And this letter provides links to resources to help prevent against cyber attacks. So if you look at this letter, it provides links to sample BAAs or business associate agreements, HIPAA security webpage, which has a full-blown risk assessment that you can use. It has webinars on the risk analysis itself, which I would watch 100%. And it goes through risk assessment tools and other fact sheets on ransomware. So HIPAA is a big deal, and most employers don't know that they are themselves subject to HIPAA, especially with self-funded plans. And so, again, I would take a look at this, and if you have this unbundled, like I mentioned before with the RxDC reporting, if you've got a typical self-insured plan with stop loss or even a level funded plan, HIPAA applies to you, and there needs to be a risk assessment conducted, training, policies and procedures in place. This is not just about a privacy practices notice. That's not being fully HIPAA compliant. You have to have breach procedures. You really have to take a look at your overall software and hardware, computers, all of those things. A risk assessment, in other words, has to be conducted with an IT professional, maybe a contractor or somebody that you employ in-house. So HIPAA is definitely a project. It's not something you can just put up some policies and procedures. Unfortunately, there's more to it than that. And this OCR letter, as a result of this ransomware attack with this huge company, is again highlighting, it's bringing up the fact that OCR really cares about HIPAA compliance and that there can be punitive measures put in place. So again, maintain compliance under HIPAA privacy and security. And again, that's something that we can help you kind of with by giving you a toolkit. There's other consultants out there that can really help, and consider working with an attorney ultimately to come into compliance with HIPAA. So just some key takeaways on these hot topics. Again, confirm with your insurance carrier or your medical claims TPA or pharmacy on the status of assistance with the Section 204 RxDC reporting that's due to CMS no later than June 1st, 2024 for the 2023 calendar year data. Ensure your coverage is affordable, that it meets minimum value, which most of you would, and that you offer the coverage to at least 95% of your full-time eligible employees and their dependents to avoid any employer mandate penalties. Update your CHIP annual notices. Review HIPAA procedures and your business associate agreements with any other vendors like your TPAs, your broker that needs to have a BAA in place because they may see the PHI that's coming from your health plan. And consider also your HRA or FSA reimbursements for general health and wellness expenses. I would consult with your FSA or HRA vendor that's running these for you and just make sure that they've seen this alert and that there is an understanding that the individuals who are reviewing these claims are aware that general health and wellness expenses can't just be reimbursed like that. Food, in other words, is something to highly scrutinize with regard to reimbursements under FSAs. So I want to take some time today to focus on the Johnson & Johnson lawsuit and get into what this is saying and what does it mean for you, because I think this is the start of really higher levels of scrutiny and frankly, plaintiffs' attorneys looking at plan sponsors, employer plan sponsors being out of compliance and not following their fiduciary duties under ERISA when they're talking about their group health plan. So let's unpack this lawsuit a little bit, and then we'll kind of finish up with what this means for you and some steps that you can take. Because if you have a group health plan and you make decisions about that health plan, meaning you decide what plan is installed and what coverage is going to take, or even you decide about claims, payments, and so forth, you are a fiduciary, even if you don't know it. So that's what I want you to take away is you are a fiduciary and you have certain legal steps that you must take, regardless of whether you knew that or not. So back to the case itself. So the plaintiff is a woman named Ann Lewandowski, and she was basically described as a whistleblower, although I think she's still employed with Johnson & Johnson even at this point. and she is currently on leave for some sort of reasonable accommodation for a medical condition. So, anyways, I think that's interesting because this individual is suing her current employer, and she's out on medical leave. So, obviously, she's maybe prone to this kind of disgruntled current employee. I don't really know, but this can be the case with anyone. So this woman actually brought the suit, and it is in class action status, which I think is interesting too. And that's why I think we've heard so much about this in the news. Now, the defendants are essentially the plan itself, Johnson and Johnson, as the sponsor of a self-insured plan. They do use a trust. They're very large, and they use what we call a Viva trust. It's not really all that important for this, although it does highlight sort of how they kind of go after the big companies first, and then you'll see it go down to the smaller employers after, kind of once they figure out that this is something they can sue over. What also is very interesting to me and a little scary, I think, is that it names the fiduciaries of the plan by name in this lawsuit. So it named these people: Peter Fasolo, Warren Luther, Lisa Blair Davis, and then there's 20 or so other members of the Pension and Benefits Committee of Johnson & Johnson. These are the people that are responsible for not only the retirement plan, but also the health benefits. And that's what is so interesting about this, is because we usually see this around retirement plan fiduciary breaches, but now it just highlights the importance of health plan scrutiny as well. And so this case is deemed a class action lawsuit. It was filed in federal district court in New Jersey. It proposes a nationwide class of Johnson & Johnson health plan participants and beneficiaries. I think they have 100,000 employees or more. And it alleges violations of ERISA fiduciary duties, which I'll tell you what that means. It seeks unspecified damages at this point. So what are these ERISA fiduciary duties that all group health plan fiduciaries are responsible for? First of all, you have to act solely in the interests of the plan participants and beneficiaries. You have to act prudently. You have to consider whether or not the plan is paying only reasonable and necessary plan expenses. You have to follow the terms of your plan document. You can't just make up terms. You have to look at the plan document, have a plan document, and know what it says and follow those terms. And in the case of retirement, diversify plan assets. But we're talking about health and welfare here. So a couple of these broken down, and specifically these were brought about in this case. First of all, acting solely in the interests of plan participants and beneficiaries. Again, the one I just mentioned on the first orange block. So this is the idea that there needs to be no conflicts of interest, which I think is one thing that they're alleging in their lawsuit, is that there was a clear conflict of interest. But you have to have this singular focus, this singular sort of methodology to the plan participants and their beneficiaries. So this can't necessarily benefit just the employer, or be an instance where the employer is getting, they're benefiting from this as well through commissions or their own increased fees. I think that's really a no-no, and it's a little more obvious, but that seems to be what was going on with this Johnson & Johnson lawsuit. Also, you have to act prudently. So prudent man standard is the prudent expert, without getting a little bit too technical here. They felt that because of the status of Johnson & Johnson, it being among other things, a healthcare company, having a pharmacy and a prescription drug division, in other words. So they should have known that these costs were too exorbitant. So it kind of takes the stance of what an employer should know in their capacity as the employer, and kind of how their level of expertise, I would say. But the process is ultimately very paramount, because they want to see, the Department of Labor and the ERISA regulations really wants to see a process, a fiduciary process that's documented, and you're able to see it and you're able to review it. And the other piece of this that was brought in is to pay only reasonable and necessary plan expenses. Reasonable doesn't necessarily mean the cheapest either. It just needs there needs to be a reason why something is as expensive as it is, or why you're going to utilize this vendor, or charge this much for this particular service. There has to be sort of a reason as to why it might be more expensive, or why are you using the cheapest when you could have better care. So again, it doesn't necessarily mean that it is always the cheapest. It's just that there needs to be sort of a process in place that examines the cost of things and acts prudently, again, for the benefit, solely the benefit of the plan participants and beneficiaries, not just the employer and their own profitability. So it's important to note too that no employer can delegate away their responsibilities under HIPAA. Even when there's a third party or an administrator, the plan sponsor must monitor those service providers and the arrangements that they recommend. So the buck stops with the employer, even if you outsource everything. Does this mean you have to know every piece of data? Not necessarily, but there needs to be, again, this process in place for examining the vendors that you use, the costs that they charge you. If you have a self-funded plan, you're able to get much more of your data, and you can examine your data, and you need to be able to learn to examine that data and make decisions based on it that benefit, again, the plan participants, not necessarily giving them everything that they would want, but just examining those costs and making sure that what is in line with the market is what's running through your plan. This just sort of common sense, ultimately, I think, is what's key here. So in this lawsuit, the overarching argument is that Johnson and Johnson and their plan fiduciaries, those folks that are mentioned by name, breached their fiduciary duties under ERISA by mismanaging the plan's specialty drug program by vastly overpaying for generic specialty drugs to the tune of millions of dollars. So if you were to read through this lawsuit, it talks about how a couple of these drugs were substantially higher, $10,000 for the drug, when the fair market value of this drug was more like $40. So why is there this huge delta for a company that should know better, in other words, which ultimately could benefit that company because maybe they have a conflict of interest there, or it could just make the plan overall way more expensive because you've got these drugs that the plan's paying for, and that increases the cost of everybody's insurance. And so I think that's the idea here, that there was a mismanagement of other aspects that allowed steerage in some places and failing to incentivize the use of generic drugs. Why was that? What was the deal here? And failing to engage in a prudent and reasoned decision-making process before agreeing to this PBM contract that requires the plan to pay these exorbitant prices. So it seems as though they just did not follow through in their process, or this piece of the process was missing. And so there's a lot of funny stuff going on here. And I think whether that was intentional or not, it just highlights the need for employers, again, you're going to hear me say this a lot, to have a fiduciary process and to really examine if there's conflicts of interest. Most of the time there wouldn't be, like in this case, but knowing what things cost and scrutinizing any sort of hidden costs or unnecessary items that are included in the cost. Why do we need this? Is there a better way to do it? Those kind of things. Ultimately, with the idea that the participants and fiduciaries are getting the benefits that they are promised in your plan document. And so the state of the political environment currently as it relates to this, it's easy to see why this is coming about now if you're sort of following all of this. First of all, we have the CAA, like I mentioned on the first slide, that was passed in 2021, and impending federal legislation of PBMs. You hear about it in the news every day, both on a state level and federal level. There is a lot of political interest in sort of quelling these pharmacy costs and the pharmacy benefit managers that have sort of passed through and so forth. There's a lot of interesting, weird games going on with that world. And so policymakers are very interested in finding solutions for it. Then we have sort of the broad consensus overall in the United States that pharmacy and healthcare itself is just way too expensive. And that was sort of the goal ultimately of the ACA passed in 2010, was to try to bring affordable coverage to 94% of Americans. Whether that or not that is what came about, I think is pretty clear that that's not what happened with the ACA. But ultimately, we're back here again trying to uncover pricing, is kind of the idea here. Uncover it. What does it cost so that we can um, push the market to push down costs, because we don't know what anything costs. If you have health insurance, you don't know what it's going to cost until after you file the claim. So that's the political environment. And I think the Johnson and Johnson lawsuit is no coincidence. This is going to be sort of a landmark case that really fundamentally changes the way employers have to look at their health plan spend. So again, it's just one aspect of this trend. And the idea of claims processing based on medical necessity to quash sort of the waste that's out there is paramount to policymakers. And just, I think, Americans at large, really, this cost of healthcare is not sustainable. And what can we do about it? By uncovering the costs and scrutinizing what the carriers are charging and what doctors, what large hospital systems are charging, things that we can do to cut costs. And so some plan sponsor takeaways. As the employer on a call here today, you might be thinking, oh my goodness, this sounds a little scary. And I think we just want to take a few steps back and just use this time to be proactive, because I don't feel as though right now the Department of Labor is going to be knocking on your door or you're going to be sued by your employees. I think this just highlights a growing trend and the need for you to turn your attention to the aspect of being a fiduciary in the first place and what that means. So, employers, you must know that you are just as much a fiduciary of your health plan as you are for your retirement plan. So if you sponsor a retirement plan, I think you understand that. You have to have the same level of scrutiny and care that you would for your retirement plan. Those same fiduciary duties apply in the same way. The only one that's different is diversifying plan assets for retirement plans. So compliance has to be buttoned up. Compliance mistakes are basically low-hanging fruit that can be fodder in lawsuits. So not just compliance with ERISA and having a process outlining your fiduciary duties and your process that you went through, but ultimately all compliance. So compliance with COBRA, with the ACA, with your flexible spending accounts, your cafeteria plans, your HIPAA requirements. All of those things are paramount for a fiduciary. You have to be in compliance with your plan. And so now is not the time to sort of say, I'm too busy for all that compliance stuff. We have to lean into it and take steps to make sure that you're in compliance. And again, it's something that BeneCurve can help you with. So reach out to us if you're concerned about just your overall compliance state. Employers who sponsor self-funded plans, or you're thinking about it, should absolutely consider setting up a fiduciary process for the health plan itself. This isn't as difficult as it sounds, and just takes the process being put into place and kind of knowing what that would look like. Also, complaints from your participants about things, they complain about claims not being paid accurately or something like that, whatever it is. They complain about their mental health benefits. You want to address them. You want to look into it and not ignore them. That's the last thing you want to do, because that can turn into more of a fire than you wanted to deal with. If you kind of don't listen to your participants, even people on COBRA, you need to consider them and review your plan documents, speak with your TPAs, really factor in the other issues around compliance. We don't want those things to go unaddressed, because they can turn into a lawsuit or a complaint, just simple complaint, informal complaint to the Department of Labor. And employers must take greater steps to monitor service providers. Who are service providers? So brokers, the TPA, the pharmacy benefit manager, any sort of outsourced other types of service providers that you use. Maybe you have a specific carve out for dialysis or specific carve out for mental health. You have to examine them and their costs and snuff out any sort of conflicts of interest that don't serve the plan well. You shouldn't be making commissions off of these things. Like there's sort of obvious conflicts of interest, but ultimately you got to scrutinize that and make sure that there's sort of a fair, reasonable cost that's applied to a particular service provider that you're using. So this is something that we can help with as well. So ultimately, again, just some takeaways here, kind of going back through all of this, and please type any questions that you have as we're finishing up here. But ultimately, we want to make sure that you are not only just checking the boxes with, okay, I've got to do this RxDC reporting, and we have to do ACA forms, and we have to make sure that our FSA is, paying claims properly. All of these things that I mentioned, we have to make sure COBRA is running properly. Ultimately, my hope is that employers will start realizing that offering health insurance is a lot more than maybe just buying insurance and offering it to your employees. It is managing a plan itself, very, very similar, if not exactly the same level of scrutiny that your retirement plan requires. So ultimately, compliance is your responsibility, but there are many wonderful vendors and us that can help you navigate this, what you need to be doing, and how to automate some of this, or how to help with some of the heavy lifting of all of these different requirements. You're not alone, and we want to be there to support you and to help you to understand what you need to be doing with the health plan requirements. So I don't see any questions coming in, so I may turn it back over to Alyssa to finish out with a few final thoughts, and then reach out if you do have another question that comes up.
Yeah, thank you so much, Sarah. That was amazing. And I'm also not seeing any questions in the chat box unless anybody has any final remarks. But yeah, again, like she said, if you have any questions that may not come up right now, but later, we're always an email away. I can connect you with Sarah, of course, or lead you in the right direction to wherever you may be. I see somebody is typing, so I might give them just a second. Okay, just a little comment. Thank you. So after this webinar, you will all receive a recording of it and also an invite to our webinar next month with a Clarity rep speaking about lifestyle accounts. So we always encourage participation in those and promote an ongoing learning environment for clients and prospects in and around employee benefits trends. So I hope to see most of you there. And with that being said, I just wish everyone a great rest of their day and week, and looking forward to April. So thanks again, Sarah.
Thanks, everyone. Have a great day.
Bye.
Bye-bye.